My name's Josh Hilliard. I'm the Compliance and Enforcement Counsel at the department. Happy to be here. Most of these are new faces, which is a good thing, because if you know me, usually there's some trouble afoot. A little background about myself. I've been at the department for 5 years now in the Compliance and Enforcement Division. Prior to that, I was in private practice for 5 years, where I mainly did insurance defense work. So I was representing municipalities, school districts, fire departments, police departments, whenever they were getting sued. So I'd like to give you all a bit of a rundown on the Compliance and Enforcement Division, what we do, what we handle. So here's a quick agenda. I'd like to talk about the difference between the Enforcement Division and the Market Conduct Division. I want to cover a very important statute that some of you may recall, New Hampshire RSA 400A16. I'd like to talk about the procedures enforcement follows, how we investigate cases, and then transition into administrative hearings, what that entails at the department. I'd like to cover the kinds of cases that we investigate, the Enforcement Division, and give you some examples, which should be pretty interesting. And then just some insights to leave you with. If you forget everything else I share with you today, hopefully that last slide will give you a couple things. So enforcement versus market conduct. There is some overlap between those two divisions. So enforcement usually focuses on single violations of law. When we get a complaint in about a producer or a carrier that they've done something to violate the law, versus market conduct, which is looking more at systematic issues, really focused on companies, of course, and conducting examinations of those companies. However, the two divisions actually work closely together. We collaborate on both examinations and investigations. There's times where, given that the Enforcement Division, the four of us there, myself, the Compliance and Enforcement Counsel, the deputy, our senior examiner, as well as our investigative paralegal, we look at all lines, both LAH and PNC. So there's times when I need to rely upon the PLAs, the product line attorneys, for those specific lines, when I need some more information, something perhaps I don't understand in as great detail as they do. So we do work pretty closely with them. And there's times they come to us, since we're running investigations all the time, they're coming to us for our expertise as to how would you approach this? What would you ask of this company to get the information we need? And it's pretty fruitful when we work together like that. To give you an idea, the Compliance and Enforcement Division investigates about 300 cases a year. Of those 300, though, probably only 15 to 20% actually result in any sort of administrative action or further dialogue with the producer or carrier in order to effect some sort of change to come into better compliance with the law. I'd like to talk about 400A16, super important. This is a common thing we run into with producers and sometimes carriers as well, where they don't respond to our requests. So any entity or individual that's subject to the authority of the insurance commissioner must respond to any request for information in 10 working days. There is a provision, of course, for good cause shown to request additional time to respond to that inquiry, and that's great if you communicate with us. One of the issues we sometimes have is we send out inquiries to producers or carriers and we get no response. That doesn't help you. It just compounds things, because then we have an additional violation, one that's very clear cut, because if you don't respond, that's a violation that both an individual or an entity can be fined for, $2,500. If you check our website, you'll see there's quite a few over the past few months that we've been fining companies where we send a request, they don't respond. Oftentimes, I give them a second chance even. I send a second request, no response, and then we fine them. And it's little things that they're able to fix quickly once they communicate with us, but you gotta communicate with us. Very important. Enforcement procedures, sort of how we get cases, how things go. We usually receive a referral from an inside or an outside source. We're not oftentimes manufacturing our own cases in enforcement. We investigate those referrals through 400A16 requests. We send out requests for documents, for information to the companies, to the individuals involved. We conduct a lot of online research. We use the tools the NAIC provides us to look into the individuals or entities we're investigating. We have quite a few reporting tools with some of the federal partnerships we have, like the FTC, when there's concerns about advertising for particular insurance products. Of course, social media can be a boon as well. Facebook, LinkedIn, what we find on there to help link people together that we know may have worked at certain agencies to gather more information. And of course, we speak to regulators in all our sister states when there are individuals that are licensed in multiple jurisdictions, as well as things like CMS or even securities. I do a lot of work alongside the Securities Bureau, the Secretary of State's office, given that many individuals are, of course, licensed as a producer, but also registered with securities because of the products that they're selling. And then lastly, of course, we interview the witnesses and or subjects of the investigation. I think as I shared previously, A lot of our investigations don't result in any administrative action. We either come to the conclusion that there is not sufficient evidence to find that there's a violation of law, or oftentimes we find there may have been a violation of law, but it involves a producer down in Florida. It's always Florida. And we find somebody down in Florida and we say, you know what, we're not gonna take all the time because it was a minor thing that they did. We're just going to make sure that when they renew next time, we can have a hard question with them if they renew their license, rather than spin up an administrative action to take their license at that time. If they're out of state, particularly if they have maybe 1 or 2 appointments and are not doing a lot of selling in the state. Cases are resolved in one of 3 ways. Like I said, closure without administrative action. If appropriate, we always reach out to the subject or the complainant to let them know that we have not found sufficient evidence to take action, or for some other reason we're not taking action. There's settlement agreements through consent orders. This is the way most of the cases where we find violations of law resolve. I'd say of that 15 to 20% where there's a violation, probably 80% of those resolve via consent order. And so that's when we found a smoking gun. We've got you. We know that there's XYZ violations. Here, we can go through a hearing, or we can approach this via a consent order where perhaps we don't levy the maximum fine against you for these violations, but you're going to agree to things like reporting to the department. You'll see, if you can, again, review the website, you'll see there's quite a few consent orders up there where a producer who may have violated the law in some way agrees to report to us quarterly for a year or 2 about their production, who they're working for, how many policies they're selling, so we can sort of keep an eye on them. Also includes things we've had in the past where some producers have had to go through community service and do some community service back. Again, sort of in lieu of more increased fines. And oftentimes what we like to do as well is assess a fine, but have some of that suspended, hanging over their head for a year or 2, really to incentivize good behavior going forward. So whatever misconduct we identified doesn't occur again. The last way it's resolved is through an administrative hearing before a hearings officer at the department. These are less frequent, but it's a quasi-judicial procedure in which I'm the prosecutor or the deputy's the prosecutor. We get to take the case against the respondent, which is either the producer we're taking action against or the carrier, and we present the case. It's not quite as intense as, it's certainly not, it's an administrative civil violation, so it's not like it's a burden beyond a reasonable doubt. It's just preponderance of the evidence, 51%. The rules of evidence are only loosely applied, which means that we try to conform to them, but it's a little more flexible so that the cases can both come to the hearing more quickly and be resolved more quickly. So I just talked a little bit about this, but they're held before a hearing officer appointed by the commissioner. The commissioner could sit pursuant to law as the hearing officer, but he doesn't. He usually assigns it to one of the other attorneys, and what usually happens is we have one attorney who's sort of dedicated in that position, but if he's conflicted out for some reason, we go to the other side of the house. So if it's a PNC issue, and I've been talking to Emily here, Emily Doherty, the PLA attorney for PNC, she wouldn't be assigned as the hearing officer. It would be someone from the LAH side, so that there's no question that there wasn't any communication between myself and that hearing officer prior to the case. They need to come in without any knowledge. There needs to be no ex parte communications, no communications from myself to them that could muddy the waters in any way. Hearing officer has 35 days to issue a proposed decision after that hearing, after which a final order from the commissioner must come within 90 days after the termination of the hearing. And the commissioner has quite a bit of latitude in terms of accepting or rejecting that proposed decision or modifying it in some way. And if that respondent is not happy, or if we're not happy at the department with that final decision, we can file a motion for reconsideration with the commissioner. You can take that under advisement and either accept or reject those proposals for reconsideration. And if not, then there's always a route for an appeal to the Supreme Court. It goes directly to the New Hampshire Supreme Court, as that's our only appellate court here in New Hampshire. Types of cases. A lot of what we do in enforcement is review license applications with red flags. Those red flags are either prior administrative actions in our state or other states, and or criminal convictions, as well as a failure to report those. That's very significant. Message should get out that not reporting those often gets you in more trouble than reporting and being clear to us, because if we find out about that, we oftentimes do, given some of the background checks that are conducted by different agencies, then that's a big problem, and we're gonna have a hard conversation about why you didn't disclose that to the department. I should make clear that there's many individuals that we license every year who have misdemeanor or even felony convictions, and it's going to depend upon what that is. So, a criminal conviction is not a bar to having a producer's license or an adjuster's license in the state. What's important is being upfront with the department, making clear what it was, and what's perhaps changed since then. We investigate some consumer complaints. As Keith said, thousands of consumer complaints come in. They're able to resolve lots of them, very satisfactory to the consumer. But some of them, there's some other issue, some violation of law, there's some problem that they're not able to quite tackle, so they'll get referred to us, and we handle them in enforcement. So oftentimes complain about coverage, misrepresentations from producers, or just outright fraud. We also investigate reports of terminations for cause by companies. Whenever a company's terminated a producer by cause, they're required by law to provide a report to the department. The report is oftentimes one line, just we've terminated them for cause, which of course gets our ears up, so then we make 400A16 requests, look to get more information from that carrier to determine why there was a termination for cause, to see if there's some action we need to take at the department given whatever misconduct occurred with the carrier that the producer worked for. All right, this should be a little more fun, hopefully. So I want to talk about some case examples, and we're going to try to take this off. Frankenstein plans. This is the first one I want to talk about. We call them Frankenstein plans in the department all the time. They are those plans that are an amalgamation of, AJ's walking over, I did something wrong. So they're the amalgamation of, there'll be like a critical illness component, a hospital confinement component, but then there'll be something like something that alleges to be like an ERISA plan that is not with really what I'd call a real employer, or perhaps a healthcare sharing ministry plan. It's oftentimes on the health insurance side. They try to mimic a major med plan, and we see a lot of, again, out of Florida, a lot of out-of-state producers selling these, unfortunately, to New Hampshire consumers, and they market it as if it is equivalent to major med, but so much, it's so much cheaper. You're going to be in great hands. And they'll oftentimes claim that it's associated with a major medical carrier, but they're not. The violations we usually find, they occur due to misrepresentations of that bundled product, given what the producer has shared with the individual who's purchasing that product. They're, of course, very concerned and surprised when they show up and they have some sort of medical event, broken arm, broken leg, childbirth, something that they go in, they're expecting to have coverage with this, and it's very little, if anything, they get because of that product. So I've taken a cut from an exhibit from a case quite a few years back, but I wanted to show you this. And one of the concerns we have, of course, is producers, particularly out-of-state producers, are very motivated to sell these because of this. You'll see the agent commission, 52%, 36%, 74, 45, 47, 78 on these different products. And they bundle them all together, and the blended is north of 50. But as I'm sure any of you who sell health insurance know and work with any clients who are on the ACA, that is far in excess of anything you're going to get through an ACA plan. And so these producers get these calls for consumers looking for health insurance, and they're highly motivated to put them in this kind of product. In 2021, we took action against a company who had bundled these together and was selling them through its agents. We fined them $250,000. We actually also got $82,000 in restitution directly to New Hampshire consumers who had purchased the products over the last 2 years. In 22, we fined 2 agents in New Hampshire who were misrepresenting these sorts of policies to New Hampshire consumers. We currently have a number of other investigations. I can't really share about that, but into other entities and producers who are selling products like these. It's a real big red flag at the department. And consumers should, of course, be careful. If it's too good to be true, if you got a producer telling you that I can get you a great product that's just as great as anything on the ACA, but it's going to be half the price, it's probably not as great. And of course, producers should always be honest in their descriptions of the policies they're selling to consumers. Here's another example, a criminal producer. So this might be a little hard to see, but I'll read it for you in the back. This is the real text message exchange that was used as one of the exhibits in the hearing, and we have the producer on the left, who writes, "Hey, I need to write an auto policy today. I need your VIN." And the friend writes back, "My VIN or Mavericks?" She says, "Yours." The response from the friend is, "I don't even have Allstate, laugh out loud." The response is, "You will." Then a few months later, "What's this? Mav said I have a policy with you. I never signed anything. I'm under my dad. I don't want to switch because I have a better rate being under him. I gave you my information because you said you just needed to write one up." This was one of about a dozen we found. where this individual got some information or started putting together a quote for an auto policy and then just bound the coverage. Yeah, don't do that. Not good. The report actually came from the agency owner. The agency owner, as soon as they found it out, I don't know if we were the first call, but we were certainly maybe the second or third call, called and said, I've got a big problem here. I have a producer, I just found this out, she's been doing these things, what do I do? And I said, thank you for calling us. She let us know. We didn't take any action against the agency owner because the minute she knew that this was a problem, she let us know so we could take appropriate action. She also, of course, let the carrier know, and they dealt with that on their end. We conducted an investigation. We obtained recorded phone calls and all these policy documents that showed the coverage being bound. We spoke with law enforcement in the jurisdiction as well about this issue regarding the allegations of fraud on the part of the producer. We went to a hearing. The producer did not show up. I would not recommend that. If you or anyone you know is involved in a hearing at the department, it's a good idea to show up. I mean, it still might not turn out quite how you want, but it's probably going to turn out a little bit better. At least you're there. We held a hearing. We hold them. If the person's not there, the department still has the burden of proof of showing that there's been a violation. So we did that, entered that as well as much more evidence into the record. The hearing officer assessed a fine as well as a revocation of this insurance producer's license, which is very appropriate. And perhaps in some ways even worse, because of the amount in question of these bound policies, the fraudulent activity, she faced criminal penalties in addition to the civil penalties at the department and pled guilty to a felony. So not a good situation. The last example I'd like to give you is mystery service contracts. So maybe I shouldn't say hope, but I presume that none of you here are selling 415C contracts, those sort of extended auto service contracts or home warranty contracts, but I'm sure all of you have gotten a letter like this in the mail. The department has been working hard over the last few years to really try to clamp down on this. And we've taken action against dozens of these companies. So what you'll see is we get a lot of complaints about these, and one of the concerns over the last few years is we were never able to identify or very easily identify who was sending these into the states. There's no identifiers as to what the company is. Yes, there's a phone number, but you call that and you just get a phone bank, and the people answering the phones are answering it for 5 or 6 or who knows, a dozen different companies. So they sometimes can't even tell you who sent out this mailer. They're just trying to sell the product. So we received a lot of these, and the concern is too that there is a lot of high pressure sales tactics and sometimes just outright false statements in these documents. You'll see here, response to the notice requested in bold. Our records indicated that you have not contacted us as if you have some obligation to or have some sort of product with them in the past, which is not true. And they make a lot of claims like this. We've taken action, let's see, many complaints every month, although it has been dwindling down a little bit, which I hope is because of the efforts we've been taking, about these mailers for both home and auto service contracts. Concerns about coverage and transparency as well, because when people buy these products, then they go to repair that vehicle, or the furnace breaks, or the central air, whatever it may be in the house, and they go to get that repaired and use the product, and they get almost nothing in terms of the coverage for that. And of course, a lot of difficulty when we have problems even identifying what the company is. We've taken action against 17 different 415C entities in the last 3 years. Penalties have included fines, restitution, suspension of their registrations in the state, as well as cease and desist orders for some of them. Important thing to remember is the last legislative session, the department worked with some legislatures to pass a change to 415C, which requires them to, one, have identifying information on any sort of mailer they send into the state, so we can know what companies are sending their mailers into the state, as well as some better protection for New Hampshire consumers, really tightening up the section about what is unlawful in terms of high-pressure sales tactics or even targeting seniors. That's one of the things, too. We've seen a lot of these go after senior citizens, and then we have issues where they don't even know what they've purchased. Sometimes companies, I had a few companies that had sold to individuals multiple times, like overlapping policies, which of course there's no value in the second policy because you already, it's questionable value in the first, but no value in the second policy when it's the same property and it's another service contract with the same terms and conditions. So really big concerns there, but we've been going after that pretty hard over the last few years. My last slide, just some insights for you all. Always respond to 400A16 requests. You just compound the issue. If we're investigating something, you may not even be the target. We usually say that, but even if you are, respond to us, work with us. If you don't, you're just going to make it worse. Maintain a robust records of any sales you make. So there's a requirement in the law that producers for 5 years keep a record of sales. And we have times we reach out to a producer because there's some concern that a consumer has raised to us, and we ask, what do you have? Show us what you have in terms of your file for this sale from 2 or 3 years ago. And they come back with, I don't got anything, or a single page or something. And then it's kind of just a he said, she said in terms of, well, they told me this, well, I told them that. We don't have any documentation or contemporaneous documentation backing up what the producer might say. Keep good records. Properly disclose administrative actions and criminal convictions. Not disclosing is always a bigger problem. Like I said, we've licensed many people with significant criminal convictions. In fact, this last year, it was an out-of-state producer, but they had a conviction for murder, and we licensed them. It was a very interesting set of facts. I'm not going to go into all of them right now, but there are significant criminal convictions that are sometimes appropriate to license. Not telling us is a bigger issue. Encourage reports of unfair trade practices to better protect consumers and the market. So I like to think in enforcement that our role is twofold, right? We're trying to protect consumers with what we do, but we have an obligation to make sure it's a fair, competitive market. We can't lose sight of that as well. A lot of times we don't know if something's going on that's violative of New Hampshire law if you don't tell us. If you see something that's strange, that doesn't make sense, you think violates the law, let us know. What you share with us is privileged, confidential, and not subject to right-to-know requests, okay? So it's not as if I get a call from one of you, and then the next thing I do is call the carrier and say, hey, John Smith just told me this. What's going on? I'll just make a blanket request, not identifying where my source came from, to get more information to see if there really is a violation of law that's ongoing.